Since 1992, the Center for Continuing Education, CCE, has presented seminars featuring the best in topics and talent. Our programs are available in online, DVD, and CD formats. CCE can also customize seminars for your law firm or corporate law department needs. The Center for Continuing Education is a State Bar of California approved MCLE provider.
This seminar is Basic Personal Injury for the General Practitioner. There will not be a significant discussion of trial tactics, but rather considerations that are imperative when you are beginning to evaluate a personal injury case, as well as basic do's and don'ts throughout the process pre-litigation. My name is Dennis Simmons, and I've been practicing law in California for approximately 22 years. During this period of time, I have litigated approximately 1,000 cases, the majority of which were personal injury cases. These cases have ranged from products liability to cases against governmental entities, wrongful death cases, and numerous cases involving vehicular collisions, including trucks, buses, limousines, and, of course, automobiles. For the sake of simplicity, this seminar is primarily geared towards the automobile case. In other issues, other types of cases, such as trip and falls, slip and falls, there are other considerations that the practitioner will want to consider. However, for this seminar, we're really focusing on the auto case. Now, the initial question is, what do you do with your initial client contact? Typically, the initial client contact will come from a referring attorney or a friend of a family member. And this initial telephone conference should be used to ascertain some very, very preliminary facts. Of course, you need to determine why the prospective client has called you. In other words, did it in fact involve an accident? Did it involve a slip and fall, a trip and fall? Was the client injured in an explosion? Most importantly, your threshold question should be, when did the accident occur? Now, why is that significant? Well, if the accident occurred approximately 6 months prior to the initial client contact, you would need to file what's called a governmental tort claim if one of the potential defendants was or is a governmental entity. Failure to file the governmental tort claim within 6 months after the accident may perpetually bar, in other words, through the statute of limitations, the 6-month statute, your client from any recovery whatsoever against a governmental entity. There are, I should add, procedures to seek relief called an application for relief from the late claim procedures. However, you really don't want to take that chance. Similarly, if the client has come to you and you find out in the initial telephone conference that nearly 2 years have elapsed since the accident, well, California, since 2003, has had a 2-year statute of limitation in personal injury actions. In other words, if there is some degree of urgency, you need to act on this matter very, very, very quickly, or you risk a situation involving serious consequences. In other words, your client's claim may be lost. Clients also typically have initial questions relating to medical treatment. Frequently, if the accident occurred within the 2 or 3 days prior to the telephone conference, a client may not have obtained medical treatment at that point. So the client may ask you, what should I do about a doctor? Well, I highly encourage you to tell your client, or prospective client at this point, to seek help from his primary care physician. If, however, the primary care physician is not available for 2 or 3 or 4 days and your client is in some distress, definitely tell your client to seek help from an emergency room at the local hospital. I encourage you not to refer that client to anything involving what might be termed alternative medicine at the early stages. And the reason for that is everything should be orchestrated, if at all possible, through the primary care physician. You should also advise in that initial telephone conference against your potential client talking to the defendant, that is the tortfeasor or adverse driver, from talking to their insurance company. Usually, the adverse insurance company will insist on a recorded statement. Your client is not required to provide a recorded statement to the insurance company. Simply not. And I advise you to advise your client not to provide a recorded or a written statement to the adverse insurance company. Why is that? Well, your client's recollection of the accident is going to vary over time. Despite what we have in California called fast track rules, in which a case is supposed to go to trial within 1 year of filing, as a practical matter, it's very, very common for 2 years or more to elapse from the date of filing until the actual trial date. Regardless of how smart your client is, regardless of your client's recollection, your client will not be able to remember the details surrounding the accident in 2 years. It's simply impossible. Therefore, the recorded statement will provide the defense attorney with fertile ground to impeach your client and find subtle differences and nuances to cast doubt on your client's credibility. There is simply no advantage to allowing your client to submit a written or recorded statement to the adverse insurance company. I should caution you, however, that insurance adjusters typically look at a refusal to provide a written or recorded statement as the plaintiff and or the plaintiff's attorney being uncooperative. Well, be it as it may, still do not let your client provide the insurance company, the adverse insurance company, with a recorded statement. At the initial telephone conference, I also asked my client to put together a list, subject of course to attorney-client privilege, the names and addresses of the people involved in the accident, as well as the identity and hopefully addresses of any potential witnesses, anyone who may potentially be responsible for the accident or may have information regarding the accident. Also, depending on the situation, I asked my client to provide me with a list of medical providers, any hospitals, any primary care physicians, chiropractors, MRI facilities, anything at all that my prospective client utilized for medical treatment prior to our telephone conversation. I also asked my client to bring any photographs of the accident, if any were taken, as well as photographs of any injuries that may have been taken as well. At that juncture, however, if my client has not obtained any photographs, I ask them to not take any photographs until we've had a face-to-face meeting. Now, for a slight deviation from auto cases, depending on the type of case, you would want your client to bring other things. For example, in a slip and fall case or a trip and fall case, ask your client to bring the shoes they were wearing at the time of the accident. The shoes will be critical later in the litigation, and if your client continues to wear those shoes, they're going to be in a much different stage come trial time. The client should also bring along any medical bills, medical reports that they might have their hands on, repair estimates regarding their vehicle, appraisals, any information relating to loss of income and employment. And I should caution you, of course, typically a client isn't going to have all this information. And you should not request that the client go out and get all of this information if it will in any way whatsoever, delay your initial meeting. Now, let's discuss the initial client meeting. Obviously, this is extremely important. This is your first opportunity to judge your client's credibility and to assess your client's goals. I've had cases where my prospective client had very, very, very minor injuries, no more than a scratch. Yet, after a few minutes of conversation, I discerned that the client had incredible goals in terms of financial recovery. Well, this may not be a case that you want to take. Similarly, you can make an initial assessment of how your client will present in deposition, how your client will present at trial.